Take up the case of Allen versus the state. Counsel for the appellant is recognized.
Thank you, Chief Justice Kennedy. May it please the court, Mose Bracey, on behalf of Mr. Allen. I hope to focus on issue 1. In short, this case should be remanded for a new penalty phase trial because the trial court failed to renew the offer of counsel prior to the penalty phase trial below. With that in mind, this case is about being faithful to the text of the Florida Constitution. In particular, it's about being faithful to the portion of Article 1, Section 16 that provides, in all criminal prosecutions, the accused shall have the right to be heard in person, by counsel, or both.
Counsel, I'm sorry to interrupt you. I appreciated your really thoughtful reply brief on the precedent and everything. But for fundamental error to kick in, it would have to be a constitutional violation, right? And it seems like the trailer opinion, which I'm assuming is the source of this requirement that the offer be renewed before every critical stage. I mean, that struck me as being completely made up and not grounded in the text at all. Could you, I mean, there's no federal counterpart to that requirement, right? In a constitutional sense?
Well, Justice Muniz, my position, I just want to make sure I'm clear on your question. You're saying that the trailer kind of reasoning and conclusion appears to sort of be untethered from the Florida constitutional text?
Yeah, I mean, I know that it purports to be applying Article 1, Section 16, but it just kind of announces this rule that it didn't seem like it was grounded in text. It didn't seem like it was grounded in history. It's not grounded in a comparison to some sort of federal baseline. And I'm not saying, I understand that it's also in our rules of procedure, which, you know, that sort of takes care of, you know, the requirement of it and everything. But in order for it to rise to the level of a constitutional violation, not to do that, it just seemed like the court just sort of asserted that. And, you know, it didn't seem like it was grounded in anything other than what the court thought would be good policy.
Well, I would disagree, Justice Muniz. First of all, if I could, I would like to address sort of the precedent and the text, but also to the extent your question concerns whether an error would be fundamental, of course, I would like to address that separately if I could. But in terms of essentially whether this court, well, first of all, I should say this. I do not believe that trailer was untethered from the Florida constitutional text. I believe that that is a correct opinion that's grounded in the actual text. Of course, I would start by saying, you know, the question is not necessarily whether that opinion is right or wrong, but whether this court should abide by it. And my basic position would be that this court should not recede from trailer. And under any view of the approach to stare decisis outlined in Poole, that would be true. And in short, that's because, trailer was not clearly erroneous. It does not conflict with some higher source of authority, whether it be the federal constitution, a statute, or a decision of the United States Supreme Court. And if I could elaborate on that a little bit, you know, this court has obvious authority to interpret state constitutional provisions to provide greater authority than the federal constitutional provisions. As a general matter, conformity clauses are an exception, but I don't believe that is an exception that applies here. Furthermore, contrary to the state's argument, the trailer decision does not conflict with the Sixth Amendment right to self-representation. And I should just back up a step and say, frankly, the right guaranteed by Article 1, Section 16, it is different in nature from the Sixth Amendment right to the assistance of counsel. Of course, the United States Supreme Court has also concluded that the Sixth Amendment implies a right to self-representation. Here, I would point out that the text of the Florida Constitution explicitly says a right both to be heard in person or by counsel. And so my basic position—
How does that, so what?
Yes, sir.
How does that make it different?
Okay. Yes, sir, Justice Coriel. Well, if I could turn to this court's reasoning in trailer, because I think the reasoning in trailer actually illuminates this issue. First of all, in trailer, this court started by saying that a primary right embodied by the relevant portion of Article 1, Section 16 is the right to determine one's manner of representation. This court then went on to say that that right, the right to determine one's manner of representation, would have, in order for that right to have meaning, that right has to apply at least each crucial stage of the prosecution. And I think what's going on there is the public meaning of the text at issue accounts for the fact that circumstances change over the course of a criminal proceeding. In particular, the circumstances change significantly from one crucial stage of a criminal proceeding to the next.
But you're not arguing that the right is any broader under Article 1, Section 16 than it is under the Sixth Amendment as, say, understood in Ferretta, are you? Or are you saying that the defendant's right under the Florida Constitution differs in some meaningful sense than as it's been held under Ferretta and its progeny to be articulated by the U.S. Supreme Court?
No, Sir Justice Coriella, I don't believe I'm trying to say that it's broader in scope. Instead, I'm trying to argue that it's somewhat different in nature. I think the fact that the Articles 1, Section 16 uses the explicit word both, I think both means something. It doesn't just say that you have the right to.
Well, help me understand. I guess that was my earlier question. What does it mean? I mean, how does that amplify the right? I mean, are you saying that under the Florida Constitution, for example, a defendant would be able to engage both in, speaking through counsel and also directly to the court? Is that what the word both means in the Constitution under your lights?
My position is that the word both at least means what this court said it meant in Traylor, which is that at one stage of the prosecution, a defendant can be heard in person, but at another crucial stage, a defendant can be heard by counsel. And so I would go on to point out that, not surprisingly, in Traylor, this court went on to say that a defendant is entitled to decide whether they require the assistance of counsel at each crucial stage. And to that end, this court also said that where a waiver of counsel is secured at one stage, it only applies at that stage and has to be renewed at each subsequent crucial stage. And again,
that's where really, because no one's this case isn't about someone asking for counsel or asking to do something different at a different stage and whether that's okay. I mean, the question is there something in the text that would suggest that it's not enough to have an informed waiver at the outset where you tell the person the rules of the game and you explain to them that, if you change your mind, we can address that later, et cetera, et cetera. Why it's a constitutional violation not to keep repeating the offer at different stages of the proceeding.
Yes, sir. Well, Justice Muniz, again, please allow me to say that we're not writing on a blank slate. Traylor has been issued, and what I would say is that the respective language, the right to be heard both in person or by counsel, that is a vaguely worded clause. And it has what I would call a broad public meaning. And it's perfectly appropriate in those circumstances where we're dealing with a vaguely worded text for a court to, in the words of James Madison, liquidate that meaning, to expound on what that means. And I don't think it was clearly erroneous at all for this court.
Counsel, I'm just struggling to see how any ambiguity that you refer to in that text is resolved by the repeated inquiries that are required by Traylor. And I'll just observe, it seems to be a feature of these cases where a defendant has chosen self-representation, that the defendants are annoyed at least and sometimes distressed by the repeated inquiries and tell the court, I've told you what I want to do. Why do you keep asking me about this? And so that they feel that somehow it is actually calling into question the choice that they have clearly articulated, and which has been explained to them from the beginning is something which does not require that they maintain that choice throughout different stages of the proceeding. Isn't that all correct?
Well, Chief Justice Kennedy, I certainly acknowledge that there have been instances where defendants have expressed some irritation with that being renewed, but I believe that's far more the exception than the norm. And if I could return to what you initially started out addressing, I would just say it's not a matter of the court clearing up ambiguity about the text. It's more that it's the court's proper role to determine how a vaguely worded constitutional provision should apply in a particular case. And I believe that that's what this court did in Traylor, and that it's simply not clearly erroneous, that decision is not clearly erroneous. It doesn't clearly conflict with some higher source of authority. In particular, it does not clearly conflict with the Sixth Amendment right to self-representation. And if I could briefly elaborate on that point, the United States Supreme Court has made clear that in determining whether the Sixth Amendment right to self-representation is violated, the primary focus is on whether the defendant had the fair chance to present his or her own case in his or her own way. And certainly simply renewing the offer of counsel at not even every stage of the proceeding, but just each crucial subsequent stage outside of the presence of the jury would not infringe upon a defendant's right to present his or her case his or her own way. So again, even if reasonable minds could disagree that the right to be heard in person by counsel or both does not necessarily require, when it's applied in a particular case, that the offer be renewed at each crucial stage. I mean, even if reasonable minds could disagree, it's not clearly erroneous. It doesn't conflict with some higher source of authority. It doesn't clearly conflict.
Could you address the waiver issue? Because obviously the issue that we've been focusing on is super interesting, but it might be kind of academic in this case, given the way this actually played out.
Yes, sir. Yes, sir. Well, what I would say there, Justice Muniz, is that my understanding of this court's precedent is that in order to waive a fundamental error, and of course, I'm distinguishing a fundamental error from a run-of-the-mill normal error, but in order to waive fundamental error, the fundamental error has to be invited. And my understanding of this court's case law, and here I'm thinking of Knight versus State, Lowe versus State. My understanding, I'm sorry, not Knight versus State, but Lowe versus State and Universal Insurance Company versus Warfel. My understanding is that in order to invite a fundamental error, the fundamental error has to be requested or at least affirmatively agreed to. And that's contrasted to merely acquiesced to. And so here though, I mean, wasn't the defendant essentially given an opportunity to cure? I mean, it seems like the only reasonable way to read what the trial court said here was acknowledging that he should have made the offer before the penalty phase started, and essentially telling the defendant, if you wanted counsel for that, then the implication was, we'll fix it, we'll do it again. And the defendant said, no, I'm fine. So yes, how much more do you have to do to waive something than that? Well, I believe for it to be fundamental error, Justice Muniz, and I would like to elaborate on this answer a little more broadly if I could, but in order to waive fundamental error, I believe it has to be invited or requested. And I would contrast that to what happened here. Here, the trial court did, after the penalty phase trial was over, did question Mr. Allen and later conduct an extensive colloquy. And in response, Mr. Allen did indicate that he had not wanted to be represented by counsel during the penalty phase. But I would argue actually strenuously that that was merely acquiescing to the court's earlier failure to renew the offer of counsel prior to the penalty phase trial. I would also just like to address why, in essence, those post hoc efforts to cure the trial court's earlier failure fell short. First of all, I would point out that those post hoc efforts did not provide Mr. Allen with a meaningful opportunity to, for purposes of Article 1, Section 16, determine his manner of representation at that crucial stage, the penalty phase trial stage of a capital proceeding. And I would note in support of that general proposition that the state and trial court both made certain remarks prior to the questioning and later colloquy of Mr. Allen. For instance, the state started out by saying, Judge, we just need Mr. Allen to reaffirm that he did not earlier want counsel at the penalty phase trial stage. And shortly thereafter, the trial court said, in essence, Mr. Allen, I just need you to affirmatively respond that you did not want counsel at this earlier stage. And then later, prior to the colloquy, the state again spoke to the court and said, Judge, we just need Mr. Allen to reaffirm that he did not want counsel. And, you know, in essence, we just want to tie up all the loose ends and make the record clear. And so I would argue that in those circumstances, it was clear to Mr. Allen that his opportunity to be heard by counsel at that crucial stage had already come and gone. I would also point out that the extensive colloquy was primarily focused on whether he desired counsel at the upcoming Spencer hearing. And I would again note that I would direct the court's attention just to the nature of this right, which is the right to determine to be heard both in person and by counsel. So again, at one stage, a defendant in Florida has the right to be heard by counsel, and at a later stage, he or she has the right to be heard in person.
But really, we're talking about this sort of gets back to the other thing. I mean, we're kind of, what the case is about really is the right to be reminded repeatedly about your right. It's not about your right to have the counsel or not. Well,
I believe that according to this court's decision in Traylor, which again, I would argue is not clearly erroneous, that in order for a person to have a meaningful opportunity, that the court has to renew that offer. And that did not happen here, Justice Muniz. And if I could just briefly on this point of whether the court's post hoc efforts cured its earlier failure, I would just like to direct the court's attentions to two Florida District Court of Appeals decisions that essentially concluded a trial court's post hoc efforts did not cure its earlier failure to renew the offer of counsel. And I believe these decisions are discussed on page 26 of the reply brief. But in Burrell-Key and Howard, that's essentially what the District Court of Appeal concluded. And just to briefly give those facts, and if I could, my hope is to also be able to address fundamental error issue after this, but to briefly address the facts of Burrell-Key, there in essence, the defendant was charged with a violation of probation based in part, at least, on some new law offenses. He waived his right to counsel at the probation hearing. The trial court did not renew the offer, but he was found in violation. He was sentenced. The trial court then asked, do you want to represent yourself at the upcoming trial on the new law offenses? He said yes. On appeal, the District Court of Appeal basically said that even though the defendant's indication after the violation of probation hearing indicated he wanted to continue to represent himself, that didn't in essence cure the earlier failure to renew the offer. Howard almost goes one step further in a way. Howard, the defendant represented himself at trial, was convicted, filed a motion for new trial. The sentencing stage played out over the course of a few appearances over the course of at least a few weeks. At the first appearance, counsel was not renewed. The offer of counsel was not renewed. The motion for new trial was denied. Some witnesses were presented. A couple appearances later, the trial court actually conducted a full Ferretta inquiry, and the defendant indicated he did not want to be represented by counsel at the sentencing stage. Even then, the District Court of Appeal concluded that, in essence, those post hoc efforts did not cure the failure to offer counsel, to renew the offer of counsel at the outset. So, at least on this issue of whether the court's post hoc efforts here cured its earlier failure, I would argue that those two decisions should be persuasive. Now, if I could just more squarely address the issue of whether the error here was fundamental error, my basic position would be that that error amounted to fundamental error, that it vitiated the basic validity of the trial, that stated differently, it went to the foundation of the case and amounted to a violation, was equivalent to the violation of due process. And I would start by noting that the United States Supreme Court and this court have noted that the right to counsel is fundamental error. The U.S. Supreme Court has stated that that right is indispensable to the fair administration of our adversary system of criminal justice. And I would also direct the court's attention to the fact that we're dealing with a particular portion of our adversary system of criminal justice, and that's the penalty phase trial stage of a capital proceeding. I don't believe there could be a more crucial stage of criminal proceedings than that particular stage. And I think that's particularly true in Florida, where one juror deciding that life is the appropriate sentence means the defendant's life gets spared. I would also note that the United States Supreme Court, and here I'm referring to its decision in United States versus Marcus from 2010, it recognized the possibility that a structural type of error could amount to plain or fundamental error, regardless of its actual impact on the trial. And I would argue here that the court's failure to renew the offer of counsel, that it's analogous to a structural error. Even though it's difficult to determine its impact, it infected or
Mr. Bracey, excuse me, but that's where I struggle. I mean, generally, would you agree that fundamental error has got to be error that made a difference in the outcome, correct?
Well, Justice Lawson, I do think that is often true. The way I read this court's precedent, and here I'm thinking of Knight versus State. I mean, as I read Knight, it sounds to me like fundamental error could arise either from the result not being able to be obtained, without the error, or if the error vitiates the basic validity of the trial. And I certainly would also.
But how would it vitiate the basic validity of the trial if the error made no difference whatsoever?
Well, Justice Lawson, I don't think we can say that it made no difference.
Why can't you say that in light of Mr. Allen's forceful and clear statements that he did not want to be represented? He wanted to represent himself at the penalty phase. So he said in his own words that if he'd been given the offer, he would have declined it. And so we know on this record that the trial judge's failure to give the reminder made no difference.
Yes, sir. Well, Justice Lawson, again, I would return to the point that I don't believe those post hoc efforts by the court to cure its earlier failure, that they actually cured it. One, I don't believe it was a meaningful opportunity for Mr. Allen to really say, I wanted to be represented.
Wasn't it a meaningful opportunity for him to say what he thinks what he would have done, whether he had changed his mind or not?
Not
whether
when
he would have changed his mind? Why isn't that?
Yes, sir. I would say that, again, it's important to recognize that the remarks that were made, the sort of lead up to those questioning and colloquy, which made it clear, I believe, that this was a formality, that ship had in essence already sailed, and they just needed to make the record clear. They needed him to affirmatively respond that was the case. And I would also, Justice Lawson, come back to the point that fundamental error, unlike, let's say, just run-of-the-mill error, it's not waived simply by acquiescing to it after the fact. It has to be invited on the front end. I believe it has to be requested or at least affirmatively agreed to. And here, I don't believe.
And I'm not talking about waiver. I'm just talking about the basic premise that it's hard to wrap my mind around the fact that something could be classified as fundamental error if it's clear on the record that would have made zero difference. And I know you have an argument that we can't tell that because of the way the question was led to Mr. Allen, but assuming that I think it's clear, why should anything be classified as fundamental error when it would not have made a difference, and the record makes that clear?
Yes, sir. Well, Justice Lawson, just to briefly repeat myself, I mean, I do think that with structural type of errors, they can amount to fundamental error. They can vitiate the basic validity of a trial, even if it's difficult to measure their actual impacts. And again, I would just say that here, Mr. Allen's sort of post hoc assurance that he had not wanted to be represented by counsel, that in the circumstances of this case, that did not prevent the error from vitiating the basic validity.
I guess one more follow-up. I mean, as I recall, you state that we should view this as a structural error, but I don't believe that you found or any case that classifies it as such.
Well, now, Justice Lawson, I would direct the court's attention, and these cases are cited on page 33 of the initial brief. Multiple Florida district courts of district courts of appeal have concluded that even where a waiver of counsel is accepted, but the offer is later not renewed, that is per se reversible error. And so I would argue that.
Are any of those cases, other than the other two that you mentioned, cases in which the record is clear that the defendant says he did not want counsel?
Well, the two I mentioned would be the primary ones on that point.
Okay.
Yes,
All right, counsel, you're into your rebuttal time. You may continue, but you are consuming rebuttal time.
Thank you, Chief Justice Kennedy. Well, if there are no further questions at this point in time, I would reserve the balance of my time for rebuttal.
Counsel.
Thank you, Chief Justice Kennedy. May it please the court, Michael Kennett for the state of Florida. This is a direct appeal of a conviction for first-degree murder and the accompanying death sentence. With regard to, and there's no question about the sufficiency of the evidence in this case to support the conviction, and there really is no question that the aggravation when weighed against the mitigation is proportionate. So the issues really do involve the right to counsel and the corresponding right to self-representation, which are essentially competing rights under the Sixth Amendment. The issue one, which is what the appellant spent his time discussing, does revolve around this court's decision in Traylor. And it's quite clear that Traylor unnecessarily interferes with a defendant's right to self-representation. How many times does a defendant have to be asked, are you sure you don't want a lawyer? And although he was respectful, the appellant in this case, he clearly expressed some frustration with the court when he was going through his third Ferretta inquiry. And he said, but I would say I've been through 2 Ferretta hearings. I reaffirmed at least 10 times, and I reaffirm right now, I would like to represent myself. I do not need or want an attorney or standby counsel. It is clear that at all points throughout these proceedings that the appellant wanted to represent himself. He was competent to do so. There are no questions about competency under Dusky or Drope. There was an Indiana versus Edwards evaluation that was performed. He was deemed competent under Indiana versus Edwards to proceed pro se. And there are absolutely no questions that his waiver, his original waiver of the right to counsel, was knowing, intelligent, voluntary, and made with eyes wide open.
What do you suggest as a former trial judge who did a lot of these? When do you give the Ferretta? When do you suggest it should be done?
Well, at the earliest mention that, or earliest indication that the defendant wants to proceed pro se. And that's exactly what happened in this case. If we go back and we look on, the trial in this case took place in February of 2019. But if you go back to November 26th of 2018, the defendant signed a waiver of representation of counsel. Less than a month later at a pretrial hearing, this is on 12/20/18, the trial court went through the first Ferretta inquiry with the defendant, and it satisfied all the requirements of a waiver, and it didn't interfere with his right of self-representation. And the trial court was very clear with the defendant that the defendant had the opportunity to re-invoke his right to counsel at any time. And I'll read to you what the trial court said. It's very clear. Primarily, I want you to understand that you'll be going through this scenario with me or with a judge at every opportunity because you have a right to change your mind. If you are granted the right to represent yourself, you can change your mind and ask for an attorney at that point. Also, the trial court said, and as I said before, at any point in the process, if you wish to, if you're allowed to proceed by yourself and you wish to have someone else, have someone represent you at that time, then all you need to do is to inquire. Just
okay, so going back to my question, if you had the choice here, you would require Ferretta inquiry to be conducted the first time, he says, at the beginning of the trial sometime before jury selections began. Is that when you would do it? Obviously, that's an important part of the trial.
Well, I would say at any time that a defendant indicates he would like to proceed pro se, then there is a need for an inquiry and at the earliest opportunity. And that's what happened in this case. It all happened pre-trial, even though he had to go through.
So let's say I'm a defendant and I walk into the courtroom right before jury selection begins and said, I don't want a lawyer. I want to represent myself. At that point in time, a judge should conduct a full Ferretta inquiry. Is that correct?
Yes, because the defendant has.
Right, but here, and in your typical case, I can more or less accept your argument but in a typical case, say it's a robbery case, you got your basically guilty phase and you got your sentencing later on, which is a small hearing. But here we have basically 2 phases involving the jury. You got the penalty phase and that follows, which is where the judge did not renew. Should there not be at least in these type of cases, given the fact that the ultimate penalty is going to be imposed, in these type of cases, should there not be, and if I buy your argument that it should be limited to just one time, should it not be one time before the penalty guilty phase and then one time before the penalty phase?
I guess I have two responses to your question, Justice Labarga. The first is that the guilt phase and the penalty phase were back to back. This is a very short trial, and the jury selection took 1 day. The actual guilt phase took a day and a half, and then after the guilt phase ended, they went right into the penalty phase, which took a half a day. So it was all very back to back over a short compressed period of time. But my second question, or my second response, I guess, is where would that requirement come from? Certainly death is different. I understand that. But the moment that you say death is different, you're suggesting, or not you, I'm sorry, an individual is suggesting.
I say it all the time.
Okay. It's a suggestion that there's a cruel and unusual punishment aspect, or that there's some kind of Eighth Amendment overlay onto another constitutional right, in this case, the Sixth Amendment right to counsel or the Sixth Amendment right to self-representation. The problem with that is when you have that kind of Eighth Amendment overlay, we have to look, because there's a conformity clause in the state constitution about the Eighth Amendment, we have to look to see if there's any US Supreme Court case law, and there really isn't. So because of the conformity clause, courts in Florida are constrained to provide no more greater rights under the Eighth Amendment than those provided by the U.S. Supreme Court.
Let's say it's a robbery case, and there's a confession, and a motion to suppress the confession is filed, and there's a hearing on that motion to suppress scheduled months ahead of the trial. And at that time, the morning of the hearing, the defendant comes in and says, "I want to represent myself. I can do a better job than these lawyers for this motion to suppress. I want to represent myself." And the judge goes through the entire Ferretta, does an excellent job at it, and allows him to waive counsel, and he represents himself. Now, should that warning not be repeated perhaps 3 months later when the jury trial begins and he wants to represent himself there as well?
The Sixth Amendment does not require it.
Okay, so just that one time?
Yes, it's at some point we have to respect the decision of the defendant to represent himself. And
well, there are two different. You see, the thing is that you're dealing with two different type of hearings. Just like in the death penalty situation, you're dealing with two types of hearings. You got the guilt phase, and then you got the penalty phase that requires a completely different view of it and how to handle it. So
but it's all
a suppression motion is one thing, and a trial is another thing. Shouldn't there be warnings in both?
No, because it's all one trial. And in this case, it is clear, the record that we have, it is clear that at all points throughout this trial, the defendant wanted to represent himself. And I want to talk briefly about Ferretta itself and what actually is a Ferretta violation, because unfortunately in Florida, lawyers too often use the term Ferretta violation to describe a situation where the waiver inquiry doesn't go far enough. But in reality, an actual Ferretta violation is the exact opposite, where a waiver inquiry would go too far and start to interfere with the defendant's right to self-representation. I just want to stress the point that we have competing constitutional rights here. The right to counsel, yes, under Gideon versus Wainwright, but also the right to self-representation under Ferretta. And so a true Ferretta violation occurs when a court, whether it's a trial court or an appellate court, puts too many obstacles in the way for a defendant to exercise his right to self-representation.
See, I can understand a situation like Justice Kennedy mentioned earlier, the fact that defendants we commonly see that in the transcripts, that they are annoyed at being asked over and over again, but that usually occurs during the course of a trial. In situations like the one I just mentioned, where a lawyer may file a motion to suppress, and 3 or 4 or 5 months later there's a trial, there's a big gap there in time. I think that the situation that you're mentioning that I would find some credibility in is the fact that during the trial, a judge is required at, what is it that we call it, each major
critical or crucial stage of the proceedings.
at each critical stage of the trial, the judge has to go back and read the whole Ferreira inquiry again, over and over again. I can see that, but I think when we're dealing with different hearings in different times, I think that's a different matter. And I think that there's a big difference between a penalty phase and a guilt phase, regardless of whether you're doing 2 months apart from each other or right after the guilt phase.
I would say, go back to, this was not a trial that was spread out over a long period of time. It was a very condensed trial because the defendant represented himself, and his defense was basically reasonable doubt. I'm going to make the state prove it. So jury selection, guilt phase, penalty phase all took place over the course of 3 days. So it was a very condensed trial, and the offer of counsel was renewed at the start of trial prior to jury selection. So the facts in this case are a little bit different than your scenario, but I would say even under your scenario, again, under the Sixth Amendment to the U.S. Constitution, all that is required is a valid waiver of the right to counsel and an invocation of the right to counsel or self-representation. That's all that is required under the Sixth Amendment. And when we have these paternalistic protections that are meant to provide additional protections for the right to counsel, we start to run the risk of interfering with the right to self-representation, which is what happened in this case, that there was trailer results in unnecessary interference with the right of self-representation. And we see it in this case, in many cases where there are numerous and unnecessary Ferreira inquiries. There were 3 in this case. The last 2 were completely unnecessary. And whether or not this case, the interference went too far, it did not. But I would suggest that if this court were to reverse and remand for a new penalty phase, that would be a Ferreira violation. A reversal in this case, based upon trailer, would be a violation of the defendant's right to self-representation. Because at all times, he wanted to represent himself, and the court would be taking that away from him. Why? Because the trial court didn't ask him between the end of the guilt phase and the start of the penalty phase if he wanted court-appointed counsel. That would clearly be a situation where those paternalistic...
After the guilt phase was done, the trial judge asked whether you would have liked a lawyer knowing what you know now, basically, after the guilt phase. And he said no. What if he had said yes? What would be the right result?
Well, that would be a different case, certainly, Justice Paulson, but that would raise a question, certainly, whether we would, at that point, would the trial court have needed to go back and redo the penalty phase? But that's not the issue in this case.
Well, I know, but what's your position on that?
So if we go back to, and again, there were 2 kind of post-penalty phase exchanges between the trial court and the defendant. One took place immediately after the jury was excused on February 20th, and then one took place the next day on February 21st at a post-trial hearing. So there were 2. But what if at either one of those, the defendant had said, you know what, looking back, I wish I had. All right. So we would have an inquiry. I guess we have to examine the record and say, okay, was he fully aware of his right? Did he know that at any point in the proceedings, he could say to the trial court, I don't want to do it by myself anymore. I'm over my head. I want a lawyer. And we would go back and look at the record and say, okay, was that made known to him? And it was. Clearly, it was made known to him multiple times. There was the Ferreira inquiry on 12/20/18. There was the Ferreira inquiry a week before trial on 2/6/19. The offer of counsel was renewed on 2/13 and 2/18. So if he had said, I wish I had, that's a different case. And we would look at the record to say, but you were aware, and the trial court told you many times, at any point in these proceedings, you can change your mind, right? But you have to make that known to the trial court. So his Sixth Amendment rights would be honored because he was made aware. His waiver would be still knowing and intelligent. And if he said after the penalty phase, I wish I had my own lawyer, then at that point in time, prospectively, from that point forward, now we have to have a different scenario where the trial court would need to inquire, are you saying that right now, going forward, you would like an attorney? There would need to be a clarification. But again, with this record where it was clear that the defendant knew he could re-invoke his right to counsel at any time, that would not be a basis for any kind of reversal or going back in time.
You'd agree, though, wouldn't you, that there's no sense in asking the question unless the court is prepared to do something if the answer is negative, right?
Yes.
It isn't just that the court would, if the defendant had at that point said, actually, knowing what I know now, I would rather have a lawyer. It can't be the case that that the court could have just said, well, now I just need to construct a record about why you're wrong, right? The court definitely needed at that point to be ready to actually do something if the defendant found that he was not happy or satisfied from a Feretta standpoint with how things turned out. You'd agree. I agree it's not this case, but you would agree with that, right?
Well, I think we need to separate out the Sixth Amendment from the state constitution. The judge asked these questions not necessarily because of the Sixth Amendment, but because of Article 1, Section 16 of the Florida Constitution and because of trailer. So again, there wouldn't be structural error at that point in time. There could be.
I don't understand. I mean, it seems like, in some ways, this whole conversation is an argument for why this should not be constitutionalized, this whole issue of repeating the offers again and again. But if we take trailer as a given legally in this trial at the point that it was happening, obviously, if the Florida Supreme Court has said that the state constitution requires you on a constitutional level to keep re-offering these things, and you didn't do it, you're the judge, you realize it, and you give the person a question. The whole point of that is to potentially have a do-over. It would be weird for a trial court to kind of say, I violated the Florida Constitution, but I'm just going to kind of manufacture a record for why I should just put my head down and keep going, right?
Yes, and once again, 2 points. You're correct, Justice Munoz, that this discussion just shows the unworkability of trailer. And I would suggest if we talked about issue 3, we'd have a similar discussion about the Muhammad line of cases, and that would show the unworkability of Muhammad, which is for similar reasons wrong. But I'll go back to a question that you asked earlier, Justice Munoz. The so-called right to have the trial court renew the offer of counsel at every critical stage of the proceedings is a non-textual right. It is, you can't look at Article 1, Section 16 of the Florida Constitution and see those words. They're not there. It is made up by the court, not this court, but by the court in an earlier decision. And so it is clearly a non-textual right. And again, it is unnecessary. In this case, there is no fundamental error and there is no structural error, because structural error would only be found if there was a violation of the Sixth Amendment. And it's unclear. There are some DCA cases that suggest that a so-called trailer error is per se. There are some that say, no, it's subject to harmless error analysis, but this court has never really spoken. And in the initial brief, the appellant makes a claim of fundamental error, and he's stuck with that. And he can't, and with fundamental error, the burden is on him, and he can't, with this record, show that there was a fundamental error violation because the trial court failed to renew the offer of counsel between the guilt phase and the penalty phase. It just can't be shown. But there are some other issues too. Why are we here? Why are we having this appeal? If the appellant throughout the entirety of the proceedings said, I want to represent myself, and also I want a death sentence, now we are having an appeal where that's being challenged. And why? Why is it the case? Well, it's because based upon this record, it doesn't indicate that the appellant ever had the opportunity to make a decision whether he wanted an appeal in the first place. Because this court's case law, Robertson, a 2014 case, says that appeal is automatic. And the trial court at the end of the proceedings informed the defendant that an appeal would be automatic in his case and appointed the Second Circuit public defender to perfect an appeal, which is what the public defender did with the representation that the assistant public defender was counsel for the defendant. And that was filed in the circuit court, even though the defendant was still pro se at that point in time. So it does appear to be somewhat inconsistent. And the state would certainly concede that once the appeal is underway, appellate counsel is the captain of the ship for the purposes of the appeal. Counsel is not the captain of the ship during the trial, but is for the appeal. But it should still be the defendant's choice whether or not to shove off, whether or not to launch that ship through an appeal. And the record does not indicate that it was the defendant's choice at all to do that. And so that's why we have a situation where at the trial, he wanted to represent himself very clearly. He wanted a death sentence. And now on appeal, he's asking for a redo of the penalty phase, which appears to be somewhat inconsistent.
What's going to be left of our case law in all this area when we're done changing all the stuff that you're asking us to change?
What should be there? because, if we'd like to discuss issue 3, we can discuss issue 3 and the Muhammad line of cases, which also suffer from a similar problem in that McCoy versus Louisiana is quite clear that it is, and we're talking about the trial here, it's the defendant's choice. And if the defendant does not want to present mitigation, then that decision should be respected. And we shouldn't be appointing what is really a guardian ad litem. And I use that term intentionally because if you go back to this court's decision in Hamlin in 1988 and Lockhart in 1995, that is the phrase that the court used, a guardian ad litem. And that's really what it is. But he's not a ward of the state. He was competent to proceed. He was competent to proceed pro se. So there's no reason to take away his ability to be the captain of his own ship. It's robbing the individual of his dignity and his ability to be autonomous because it's his trial and it's his life at stake. And McCoy versus Louisiana says that. And it's interesting to note that McCoy was a death penalty case. So it's not, I'm not trying to take away jurisprudence. I'm just advocating that some of the court's jurisprudence is out of step with US Supreme Court case law. And I would note, going back to the Robertson decision, it was Chief Justice Kennedy joined by Justice Polson in a dissent. And the first sentence of Chief Justice Kennedy's dissent cites to a 1983 US Supreme Court decision in Jones versus Barnes. And the majority opinion ignores that decision. But 2 years ago, the US Supreme Court in McCoy cited to Barnes for the exact same proposition that Chief Justice Kennedy cited to it in his dissent in Robertson. And then just last year in 2019, and I believe it was the Garza decision, the US Supreme Court once again cited to Jones and to McCoy for the exact same proposition that Chief Justice Kennedy cited to Barnes in his dissent in Robertson. So it's, again, I'm not trying to take anything away, just trying to bring this court's jurisprudence back in line with US Supreme Court case law. So barring any further questions, the state respectfully asks that the court affirm the judgment and sentence in this case. Thank you.
Right. Thank you. Thank you, counsel. Mr. Bracey, before you start your rebuttal, is there anything in the record that shows whether your client wants this appeal or not?
Yes, Chief Justice Kennedy. If you look on pages 1150 through 1151 of the record, at a pretrial hearing, Mr. Allen discusses the possibility of filing a motion to suppress his statements. He ultimately does not file that motion, but he makes it clear in that discussion that if he receives the death penalty, he intends to pursue an appeal. And I can assure this court that if Mr. Allen didn't want to pursue this appeal, this court would be on notice of that fact. So does that answer your question, Chief Justice Kennedy?
That does.
May I proceed? Oh,
please do.
Thank you. Well, first of all, I hope to hit a number of points. You know, one, the United States Constitution in the 6th Amendment says, in all criminal prosecutions, the accused shall have the assistance of counsel for his defense. Nowhere does it say that there's the right of self-representation. That's a non-textual right that the United States Supreme Court has applied in that amendment. In contrast, Article 1, Section 16 states, in all criminal prosecutions, the accused shall have the right to be heard in person by counsel or both. So we're dealing with a textual right here, whereas the right to self-representation is a non-textual right.
But to the extent that there's a difference textually, it seems like it's worse for you.
Sorry?
Because there is this, you know, I don't know. I think the state might be overstating the idea that it would violate the 6th Amendment to, you know, have these repeated offers. But, you know, here you do have a textual right to be heard in person or by counsel or both. The person is given a choice at the beginning. They make a valid waiver. They are fully informed, et cetera, et cetera. And so, you know, I think the argument for the tension is stronger from a state constitutional perspective.
Well, Justice Muniz, I simply disagree. I think the word both has to mean something. And what I think both means is what this court said in Traylor, which again, does not clearly conflict with higher authority. And that is that for that right, the right to determine one's manner of representation to have meaning, it has to apply at least each crucial stage of the prosecution, meaning you can choose to be heard in person at one, but you have the right to be heard by counsel at another. So
right.
I think
and everyone agrees, I think that's a common denominator. Everybody agrees with that. I think the question is just, in order to make an informed decision as to what the person wants, again, recognizing that they can change their mind? Do you have to ask them again and again, or is it sufficient as it would be under federal law to just ask them the one time and then put the burden on them to change, to speak up if they've changed their mind? I mean, that's the constitutional issue in the case, right?
It is, Justice Muniz, and I would say this: assume reasonable minds could disagree on that point. Even then, it's not clearly erroneous. This court has already spoken in Trailer, and that should carry the day. Again, it does not conflict with the Sixth Amendment right to self-representation. I mean, the U.S. Supreme Court has made clear that it doesn't violate the Sixth Amendment right to self-representation for a trial court to appoint standby counsel over a defendant's objection. It doesn't violate a defendant's Sixth Amendment right to counsel for standby counsel to participate to some limited extent in a trial before the jury. It doesn't violate the Sixth Amendment right to self-representation for a severely mentally ill but competent defendant to be refused to allow to represent themselves. So again, we have a defendant who understands the consequences of waiving their right to an attorney, but they're still not allowed to represent themselves. I would suggest that if that's the case, it borders on the absurd to think that simply renewing the offer of counsel outside of the presence of a jury would somehow violate the Sixth Amendment. If that was the case, what would not violate the Sixth Amendment right to self-representation? If I could also point out that, let's see, the state quoted a portion of a pretrial hearing that I think it's important to go back to. The court told Mr. Allen, primarily, I want you to understand, and this is at page 859 of the record, you'll be going through this scenario with me or with a judge at every opportunity because you have a right to change your mind. If you are granted the right to represent yourself, you can change your mind and ask for an attorney. And I would suggest that the takeaway from that is if you change your mind, we are going to be having this colloquy regularly, and that's when you'll be able to express the fact that you changed your mind. So I don't think it's right factually to say Mr. Allen was on notice that he could change his mind at any time. I would also emphasize strongly that Mr. Allen may have waived his right to present mitigation. He may have occasionally expressed the desire to be sentenced to death in order to be housed on death row rather than a general population, but he was not a death penalty volunteer. He's not a defendant who failed to put up any fight and actually asked to be sentenced to death. Again, at this pretrial hearing, he made clear he would want to take an appeal if he got sentenced to death. He didn't plead to first-degree murder. He insisted on a trial. During jury selection, he requested individual voir dire, although that was denied. At the guilt phase trial, he gave an opening statement where he said, the state has to prove my guilt. He didn't waive his right to a penalty phase jury. Again, he never expressed the desire to be sentenced to death in front of the jury. Perhaps most importantly, immediately after the jury was dismissed following the guilty verdict, he said, I'm not seeking one particular sentence or the other. This is on page 295 and 296 of the record. I'm just allowing this process to happen. It'll be whatever it'll be. I've never not been willing to accept the consequences for my actions. If they come back with a death verdict, they come back with death. If they don't, they don't. And if I could just very quickly conclude, this court has recognized that in the words of Justice Joseph Story, every word employed in the Constitution is to be expounded in accord with its plain, obvious, and common sense meaning. Here, Article 1, Section 16 plainly states that a defendant shall have the right to be heard both in person and by counsel. Mr. Allen was not afforded that right. This court should be faithful to that text and reverse the death sentence imposed below. Thank you.
Thank you. We thank both of you for your arguments in this case today. The court will now prepare to take up the last case on today's docket, the Florida Department of Health versus Flora Grown.